just a little bit about me. So I do work at the UCLA Veterans Legal Clinic. We provide various civil legal services for veterans at the West LA VA in Los Angeles. And that includes doing infraction defense for veterans. I work quite a bit with law students, as you might guess, as being part of the law school, and including certified law students who are able to take these cases and argue the cases in court under my supervision. So just quickly, the learning objective for today is for hopefully at the end of this, you'll just understand like the basic legal process for infractions. I am going to be focusing on kind of the legal end of things, specifically for cases in California Superior Court. So depending on where within California you're working, you may also come across occasionally a federal infraction. For instance, again, working with veterans, the VA itself is patrolled by the VA Police Department, and so sometimes we also encounter veterans who are getting federal infractions. That is not going to be covered here today, and so you may encounter something similar too. So just to say that this is going to be focused solely on state cases. So before we really get started, I did kind of just want to take a minute to talk about grants past v. Gloria Johnson. I think it is important to recognize that's a big piece of, I think, the reason that this work is kind of gathering a lot of interest right now, right? And so for people who may be less familiar, grants past v. Johnson is the Supreme Court case that just came down this summer that essentially found that citing people for sleeping in public when they have nowhere else to go is not a violation of the Eighth Amendment. And so I think what we're seeing in California, and where a lot of concern is that that may and really is leading to a rise in anti-camping laws and enforcement against unhoused people and just the criminalization of homelessness. I do want to point out that, when we talk about what we consider quality of life citations, we're also talking about other things that aren't solely the anti-camping infractions that people might see, but also things like littering, public intoxication. Another example might be something like expired registration or tax for people who are staying in their cars. And so even though Grants Pass has allowed for there to be more enforcement of anti-camping ordinances, we do think it's important to point out that these types of quality of life citations that disproportionately affect unhoused people are things that have been cited and have been continuously in effect since well before this case went forward. The other thing I just want to make sure people are aware of is RAP's Legal Defense Clinic project. That is a great resource if you are thinking about wanting to put up like a community-based clinic and thinking more in terms of like, what does the relationship look like with community organizers or those sorts of things. That's something that I would also recommend that people can take a look at. We're not really going to get into any of that today. Like I said, we're just focusing on the actual legal issues and how to defend these cases. But if you're thinking more about the considerations for standing up your own clinic or anything like that, that might be another resource that you would be interested in. Okay, so there's basically two things we're going to cover today. We're first going to do a general overview of traffic court for the uninitiated, so you can kind of understand what that system looks like and kind of the process. And then after we go through those components, then we'll talk about how to actually address the tickets, where to address them, what types of defenses, ways to get the tickets dismissed, things like that. So starting with the overview of traffic court. First, just a little bit about what even is traffic court. So traffic court is its own type of courtroom. They are infractions, so they are, technically a criminal type statute, but it's not a criminal courtroom. It's also not a civil courtroom. You will probably end up in a specific traffic courtroom. So like if you were to go on your Superior Court's website, often they have the divisions listed, and one of those divisions will actually be traffic court. So it's kind of its own thing. Traffic court is very informal. It's one of the most informal courtrooms, if not the most informal type of courtroom that I've ever been in. It's very high volume. It's a place where there are very few attorneys on really either side. So most of people are unrepresented pro per litigants who are coming in. There's also on the state side, generally there's not a prosecuting attorney either. So it's often the officers and the pro per defendants, and then occasionally you'll see an attorney in there here or there. There's also no public defenders because these are not cases where there's any possibility of incarceration or jail time, so there's no right to a public defender. The cases are all going to be infractions. This can get a little confusing because occasionally you may come across someone who is being charged with something that could be charged as a misdemeanor or an infraction. If it's in traffic court, that means it's being charged as an infraction. If it's something that's going to be charged as a misdemeanor, that is going to go to a regular criminal courtroom where, again, they'll have access to a public defender. And then also because these cases don't have the possibility of any type of jail time, it means that there are no juries. So the cases are decided by sometimes a judge, sometimes by a commissioner, which is similar to a judge, more like a career person rather than appointed person, and sometimes a judge pro tem. So judge pro tems are, judge for a day type of people. So those are private attorneys who are volunteering as judges for a day. It's the sort of thing that any of us could sign up to be a judge pro tem as well. So the judge pro tems can be a little bit tricky because it means that you are less likely to know anything about your judge going in, but sometimes that can be for good or for bad. So just to know that there are these different variations of who you might interact with in traffic court. So generally, there's 3 phases. This is how I think about it. So the first phase is the arraignment, second phase is trial, and the third phase is what we just call sentencing and compliance. At any of these phases, there are strategies to try to address the ticket, which we'll go through. So at any one of these phases, theoretically, the case could get dismissed or resolved or anything like that. You don't necessarily have to go through all 3 phases, but just generally, these are the 3 phases that we're working in. So the first phase, arraignment. So the arraignment is the first appearance. This is the primary goal of the arraignment is to enter a plea. So the options for a plea are either guilty, not guilty, or no contest. No contest does essentially mean that there is a guilty, that there is guilt, but there is no like civil component of that. So often people will choose to plead no contest so they don't carry additional civil liability, but they would still have the same, consequences as a guilty plea. And then this is also the first opportunity to request a dismissal to the judge. This is also the point if the case is not dismissed or if the defendant is not pleading guilty or no contest. This is also where the trial date will be scheduled. And again, because these are, theoretically under the umbrella of a criminal, there is a right to a speedy trial. So those trials are generally set within 45 days of the arraignment. So that's very, very fast. But that can also be waived because that is the defendant's right. So if your defendant needs more time or if you just need more time to prepare, you can waive that right and schedule out the trial to a later date as well. So I like this video because I think this kind of captures what it's like to be at an arraignment, which is to say you watch people all come in, and then you slowly but surely watch them all come out. And it's just processing through as many people as possible. What this can mean for the judges is they're trying to get through this high volume of people, is that often they're trying to move people through very, very quickly. Of course, this depends on every judge and how they choose to run their courtroom, but often they are just trying to process people out so that they can get through their next set of arraignments. And what that can also mean is that as an attorney, if you are trying to make an argument to request a dismissal, you should know that you may be going into a situation where you're going to need to do a little bit of advocacy with the court, even just to get them to realize that you're going to spend some time talking about your case and not simply entering a plea. Generally, arraignments are also a place where, depending on the judge, as an attorney, you either usually go first or go last. So, it may be a place where you end up being there for, half hour, or you may end up being there for a couple hours. I will say I know that usually it's nice to go first because you can just kind of go on to the next part of your day. But there is also a real advantage to going towards the end or at the very end of the judge's calendar because you also get a much better sense of how they handle the tickets, how they think about them. To the extent you are requesting a dismissal in the interest of justice, that can also be a really great opportunity to understand what might or might not be compelling for your judge. So we'll talk more about the request for dismissal in the second half of this training, but just to say that's kind of like the first piece of the puzzle. Oops. Okay. So assuming that you've gone through arraignment and your case is still moving forward, then the next step is trial. So thinking first about kind of what happens on the day of trial. So I'm not going to talk right now about how to prepare for trial or anything like that. I think that is the kind of skill that lawyers already have. You know to review the rules of evidence, think about what your defenses are, all those sorts of things. So I want to focus more on like what it actually looks like. So when you go to court for a trial, before the trial actually happens, there will be an opportunity, this is pretty common too in other courtrooms as well, to talk to the officer involved in the case, or even find out whether the officer is present. So it is common for officers to not show up for cases. And so to the extent that, you are present and ready for trial and the officer doesn't appear in court, that means that the case will be dismissed because the officer is not there. So sometimes you can win a trial simply by, or the case will be dismissed simply by showing up. But assuming that the officer is present, you will have an opportunity to actually talk to the officer before you move forward with the trial. That's a good opportunity to find out whether the officer has any evidence, whether the officer has an independent recollection of the ticket. Sometimes the officers are willing to simply dismiss the ticket. Sometimes they're not present for your particular case, and they may say, I don't remember this case. I'm going to ask for it to be dismissed. That's great. You can also make arguments to the officer at that point as well to about why your case should be dismissed. And if the officer supports it, you can actually kind of present it jointly to the court. And generally, in those situations, the courts will be pretty deferential to any request or recommendation that's coming from both the officer and from the defendant. Assuming, though, that doesn't happen, then it would move into trial. So if you were to move into an actual trial, then that is something that is very, very informal. It can go very quickly, and you as an attorney sometimes need to like slow things down and make sure that you're really going through all the steps. So the trial starts with the officer. The officer is the representative of the state, and they'll present their case to the court. An experienced officer can be really good at this. They tend to know exactly what the elements of their tickets are, and they can run through an entire ticket in, a couple of minutes even. And after they do that, you will have an opportunity to cross-examine the officer to ask any questions that you may wish to ask related to your specific case. You would also have an opportunity to present your own evidence, whether that means the defendant testifying or not is obviously going to be something that needs to be decided for every case in each individual. If the defendant is testifying or if you have any witnesses testifying, then the officer will also have an opportunity to cross-examine the officer. Very occasionally, I think I've had maybe one case, so it does happen, but it's not as common. You may also have a city attorney or some other prosecuting attorney who is present to present the cases. So that is a possibility as well. It's just not as common in what I've seen, but again, that may depend a little bit on your county, on your city, and kind of how they're choosing to move these cases forward. So being prepared for either a trial against an officer or a trial against the city attorney, both are possibilities. So after the trial, of course, there would be a decision about whether the defendant is guilty or not guilty. So assuming that, if they're not guilty, the case is dismissed, that's the end of it. Great, nothing to do. If they are found guilty, or if at this point you've put you've put in some sort of plea deal or anything like that, then we'll move into the next thing, which is trial and sentencing. So, or sorry, sentencing and compliance. So at the point that the ticket is there's been a finding of guilt, or the defendant has put in a plea of guilty or anything like that, then it's up to the court to determine what the required sentencing is. And so there's really, I think of this as the biggest thing is fines and fees. So that tends to be the biggest challenge for our clients. The court will determine how much the base fines are, if there are any additional court fees or anything like that, and they will tell you how much that is going to cost. Your defendants may have the opportunity to do community service, or at least request community service, to lessen the amount of the fines and fees or take care of it completely. So this is an opportunity to request community service if that's something that your defendant is interested in. But just be aware that community service often has a fee to sign up as well. So it's not necessarily a free option. It tends to maybe be a little bit less money than the fines and fees that are being assessed. The other thing to be aware of is that if it's a case that's a moving violation, so if you are doing any cases that are violations of the vehicle code and specifically moving violations, those will probably carry a point with them. The points are the system that are used connected to a person's license. And if you accrue too many points, you can end up in a negligent operator status and your license can be suspended. The other thing about points is that they can also lead to higher insurance rates. And so in California, most things are either 1 point or 2 point for the vast majority of drivers. And there is an option to do traffic school for people if they qualify. You are limited as far as how many times you're allowed to do traffic school in a certain amount of time. I believe you can do it once in a year or maybe 18 months. I would need to double check that, but there is a limitation. So it's important to know that. But if you do traffic school, then that would prevent the point from going on to your license. So sometimes that's a good option for clients, especially if they're worried about their insurance premiums. Oh, yes, 18 months. I think that's right. Thank you. So that is an option, but again, there are fees associated with traffic school. So determining whether that's a viable option for your client is something that you'll need to talk through and think about with them as well. The last version of tickets to also be aware of that can kind of fall on this is also correctable violations. So things like a broken taillight, for instance, or tinted windows. Those are the sorts of things that if you come in and you can show that the issue has been fixed and corrected, then the court will generally dismiss those tickets with a small fee. I believe it's like $20. And so that's something that can also be addressed at this point. All right. So just as like a quick review, essentially, if the tickets are coming in to you all from like the very beginning, we have these 3 phases, right? The arraignment, the trial, and then sentencing and compliance. But often we also know that our clients are coming to us at various stages of this process, or they have older tickets that they haven't had a chance to address and things like that. And so that's when things get a little bit more complicated. So you may end up with tickets where you see an FTA status or an FTP status. FTA stands for failure to appear. Failure to appear is exactly what it sounds like. It's that the defendant failed to appear at a court date. So essentially this means that they missed their arraignment date, or they missed the date on their ticket where they were supposed to schedule an arraignment. So essentially that's what that means. These cases, you can get a failure to appear, and if it takes too long, often the courts will send those tickets into collection. So even though there's not a conviction or a guilty plea or anything like that, they still will get moved into collection status while they have a failure to appear. These failure to appear previously also could lead to suspensions of driver's licenses. The court would contact the DMV and tell them that the defendant failed to appear, and then the DMV would put a license hold until that was addressed. And it could also lead to additional civil assessments. There have been some changes in the law. At this point, the civil assessments should be waived. The license holds are a little bit more complicated. We'll address it later, but just to kind of be aware that that's something that can come up. The other thing is the failure to pay. So a failure to pay status is when the ticket has already been adjudicated. So the defendant already appeared, they pled guilty or they were convicted, but they never paid the fine. So it's simply just a failure to pay the fines. These types of tickets can be sent to collections. At the point that's in a failure to pay, there's already a conviction. So these tickets can't be put back into the calendar because there already have the conviction on them. But the failure to appears can. So this is just, you do not need to look at all of the details on this. This is just to kind of map out really what the small steps are for a traffic ticket. And at the top we have, so that's where the ticket is. And then essentially there's two options. Either you miss your arraignment or you attend your arraignment. If you attend your arraignment, then the case is kind of move forward in the way we talked about. If though you missed your arraignment, this orange section that I circled, this is kind of like where you missed the arraignment. These are where these different consequences may pop up. At any point, these cases can be moved over to the other side and be put into the regular schedule by scheduling an arraignment. So it's just to say that this is where these tickets can kind of be put back into the process. Okay. So now that we've kind of gone over generally how the process works, where you might find the tickets, we can talk a little bit about how to actually address the tickets themselves and the strategies that can sometimes be used. So I think of this in kind of like three stages too. Court is where we're going to focus. Kind of what are the strategies for going to court, getting into court, addressing things within the court. It's usually where we as lawyers feel most comfortable. There are certain things though where the DMV may be the right place to address something. And then also we'll just finish off by noting that there are some local programs, but the vast majority of what we'll talk about today is going to be actually what to do within the court. Okay. So the first thing, this goes back to that map I just showed. So the first thing is just for court getting it to a judge. So just trying to put a case on calendar. If your case is up to date, it may, when the client comes in, they may just have a court date scheduled on the ticket. So it's important to look at the ticket. Or they may have a date that's called an appear by date where they need to just contact the court and schedule the ticket, schedule their arraignment. If it's in a failure to appear status, then that's going to require an appearance as well. Generally, we see these, at least in LA, and every court system is a little bit different. So kind of talking to your traffic court clerk can always be useful in this. But if a case is in collections, then often you need to actually contact the collections company itself, and they will be able to put the case onto the court calendar. There's usually an actual specific calendar for collections type cases. So you would just call them up, tell them what ticket you're calling about, and they will put it onto the calendar. If the case isn't in collections, they can just call the court and ask the court to put it onto the calendar. Either way. If you have a failure to appear, then you can't put it into the regular calendar, but you can, if you really want to get in front of a judge and actually argue for a judge, you can submit the ability to pay petition, which we'll talk about, and actually request a hearing. There are, or there have been, at least in the past, for some counties, the opportunity to walk in and actually just walk into the courthouse, put your case on calendar for later that day. That varies quite a bit, but courthouse by courthouse, county by county. My experience is that between the significant budget cuts back in around 2013, and then also with COVID, a lot of those programs no longer exist. However, it is worth, just contacting and getting your traffic court clerk and asking them if there's any sort of option or opportunity for that. Okay. So once you get the case in front of the judge, that's the first goal, then the first thing that we are always thinking about for ours is a request for dismissal. So under Penal Code 1385, the court may dismiss cases in the interest of justice. It's a discretionary option for the court. It is technically, this is a little bit of a wonky thing, but just be aware of. Technically, the defendant, there's not really a mechanism for the defendant to move for the court to do this, but we can, submit something to the court recommending it, and asking the court to decide to dismiss the case. It can be made at any time, so you can make it at the arraignment, pre-trial, even post-trial. You can continue to make these requests. Generally, we just make it at each of those options, especially if the case is going to be in front of multiple judges, as sometimes they get moved from judge to judge, depending on the stage of the case. It never hurts to renew a request for dismissal. And then they can be made orally or in writing. We generally recommend putting them in writing, just for reasons we'll talk about on the next slide. When they're made in writing, I think of it as it's very similar to a motion. So instead of a notice of motion, we call that just the request for dismissal, because again, it's technically a request, not a notice. Then there's a memorandum of points and authorities and whatever supporting evidence we might want. So as far as if you're just trying to imagine what does a written request for dismissal look like, it looks very, very similar to a motion. And then some courts may require service on the prosecuting agency in advance. So that's something that, one, if you're in this practice, you may learn that about your particular judge, and you can also always contact the courtroom beforehand and see if they have any special requirements for how they want these cases to be addressed, or how they want their request to be addressed. Okay. So when you're thinking about the request for dismissal, what's the interest of justice? I always tell my students, I'm like, this is a good opportunity for you to really think expansively and think creatively. And so I always tell them it's whatever's compelling, whatever you think might be compelling, we should workshop that. So often what that looks like is it can be focused on the hardships of the individual, what was going on in their life at the time of the ticket, how that ticket is continuing to affect them today, anything like that. For our clients, this is for veterans, one thing that we kind of find that happens quite often is our clients, if they have, a serious PTSD diagnosis, going to court itself may be so stressful that that's the biggest hardship. It's not even necessarily the ticket itself, but it's being in crowds, kind of being in a place where they can't really control the area. And so that's something we may raise for the court too. You may also think about attacking the underlying offense itself. So, for example, a request for dismissal in the interest of justice, if the underlying offense is for failing to register your car for outdated registration, and the client no longer has that car, they no longer own the car, maybe that well, what is this ticket really serving? The car is never going to be registered to this client again, because they no longer own it. Similar to thinking about an anti-camping case, right? What is the value of ticketing someone for sleeping on the sidewalk when they have nowhere else to be? And so there are ways to kind of think about that. And also the age of the ticket is another one, a pretty straightforward one. Just if the ticket's really, really old, that might be a basis to dismiss it. One thing to be thinking about within this is whether you are admitting to any elements of the violation itself in your request for dismissal. And that's a strategy question. It's a question to talk about with your client, so that they understand. Because if you're thinking about this, especially as you're putting together a declaration for the client or anything like that, if you're explaining what happened to them and it's a really compelling kind of story, that may support a dismissal in the interest of justice. If you explain yes, I was sleeping on the ground. However, I had nowhere else to go, and I had been at a shelter before, but it didn't serve me, or whatever that looks like. And so that might be really compelling, and maybe that will lead to a higher likelihood that the case will be dismissed. However, the other thing to keep in mind is that if the case is not dismissed, if there is a declaration where your client under penalty of perjury has stated that they did violate the municipal code or whatever, whatever code that they've been charged with, then that may affect what a trial would look like. And so that's something that, again, there's not necessarily a right or wrong answer to that question. It's just more making sure that you as the attorneys are thinking through what it means to include that information in the declaration, and that you're also talking to the client and they're agreeing that that is the way that they would want to move forward or not. So thinking about other types of supporting evidence that you can include in addition to your declaration from your client, but also like letters of support or other like certificates for veterans, their DD-214, which is like their discharge document, kind of whatever you can use to help paint a picture for the judge to humanize your client and make the judge want to find for your client. That's kind of how I'm thinking about this. So at the bottom, I have these pictures because I think this is how I kind of think about it. It's like, walking in, your client for this judge is going to be kind of this like first picture, which is like a faceless blob of that we know that's technically a person, but we don't know anything about them. It's not compelling. It's just like who is that? Why would I care about that? A good request for dismissal will get you to the second thing, which is this picture of a kind of a line drawing of a person. You're like, okay, I kind of see what this person's about, but I really don't know anything about them. And, it's not really, I'm not really connecting with it. It's just kind of like this picture. Um, but I might find them like interesting or compelling or something like that. And then kind of the best request for dismissal, what we're always kind of going for is painting that full picture of who our clients are. They often have like rich and important and compelling stories. And so kind of thinking about if we can get to that third, which is actually a picture of a person, of a human that we can connect with a little bit more. And so trying to move the judge from that faceless blob all the way to an individual who I could like see on the street, recognize could be my neighbor, thinking about in that type of way. Okay. So in addition to a request for dismissal, there's a few other filings that are kind of some of the most common types of filings that you might see. So one would be a demur, if the ticket is facially deficient, then you could file a demur on that. The 41-500 motions, these are dismissals when the defendant, after the ticket was committed to CDCR, so to prison or to jail under realignment. In practice, I've also seen it that essentially a lot of judges will just dismiss if they were also just in jail generally, like if they were incarcerated, they may be just willing to dismiss in those situations too. And then again, the ability to pay petitions. So again, the ability to pay petitions are only to address fines and fees after a conviction. So this is, usually further down the line is when we would do something like this. And for an ability to pay petition, that is a court form that gets filled out. You can request a hearing on that if you want to humanize the client more. And that's also an opportunity to show why just the fines and fees themselves may be difficult for the client. The court can do a few things with those. The most common things are they could offer community service instead of the full fines and fees. They could reduce the fines and fees. They could put a person on a payment plan as well. Technically, under the rules of court, I think they could kind of adjust anything under sentencing under an ability to pay petition. They do kind of have a caveat for whatever else might be requested, but usually it's being used for focusing on the actual fines and the fees themselves. All right. So then I do also want to take a minute to talk about the necessity defense. Going back to, Johnson or Grants Pass v. Johnson, this is something that if you listen to the oral arguments, that actually the justices bring up quite a bit as well, asking, well, can't an individual just bring a necessity defense? So I think it's important that we recognize that, yeah, when can we bring a necessity defense? So I put this up here, just very broadly, the idea for a California for an affirmative defense is that if the let's say the defendant did violate a statute, did violate a penal code or vehicle code or municipal code, whatever that might look like. But they did it because it was necessary to prevent some other sort of like harm or evil, then there may be opportunities for necessity defense. So this is essentially what the jury instruction looks like for the necessity defense. I did shorten it a little bit because it's pretty long, but you can see what the different elements are for the necessity defense. But I just want to highlight and raise that, especially as we are expecting there to be more of these anti-camping cases, that we're also thinking a lot about what a necessity defense could look like. Also, an important thing about necessity defense is that it it has a lower requirement as far as proving the affirmative defense. So it's not like you have to proving an affirmative defense. You do not have to sorry, I forgot what I was saying there, but just say it has a lower standard of proof than what the prosecutors have as far as a conviction is concerned. So just making sure that you're aware of this, that you can look at the jury instructions. I think are always a great place to start with these types of matters. And then also obviously looking at more case law and things like that too. Then I did want to take a minute to talk about license suspensions. So the thing about license suspensions, we're in a little bit of a strange moment for license suspensions because as of January 1st, 2023, courts are no longer supposed to report failure to appear violations to the DMV. So how the process used to work is that the court, if a person missed their arraignment or they had a failure to appear, the court would contact the DMV, tell them about the failure to appear, and then the DMV would put a license hold on their license, which meant that their license was no longer valid until they addressed the failure to appear. As of January 1st, 2023, the courts are no longer doing that. However, the DMV still has these license holds from before January 1st, 2023. So say you were unlucky and you had an arraignment on, December 31st, 2022. If you had a failure to appear from that day, that could still be reported to the DMV, and the DMV could still have a hold on your license for that failure to appear. Those old holds are still in effect until January 1st, 2027. So there's just this kind of strange twilight time that we're in right now, where if you have something older, you could still have this suspension. But moving forward, no additional suspensions should be created. And then in a year and a half, 2 years, then there should just be no more of these suspensions. But for the next couple of years, if you do come across a client who does have one of these license holds that's specifically for a failure to appear, to address that, to get their license reinstated, you would need to schedule them for an arraignment, ask the court to clear the hold, and then once the court has cleared the hold, the defendant needs to contact the DMV and request that their license be reinstated and pay a reissue fee. So removing the hold does not mean that the license is valid at that point. It just means that the DMV will lift the hold itself so that if a person comes in to reinstate their license, they'll be able to do that. This is an important point because a lot of the times our clients can get confused and think like, oh, the court said that I don't have a hold anymore, so my license is now valid. No, that's not the case. Not until you actually go to the DMV and go through their process too. The other thing to be aware of, and especially useful as these are only going to be slightly older cases now, is that there's also a record purge. So the DMV is regularly purging any failure to appears for tickets that are older than 5 years. So if your client happens to have an older hold that's from more than 5 years ago, you can actually contact part of the DMV called the Mandatory Action Unit, and the Mandatory Action Unit will go ahead and they will take care of removing that hold for your client. Now, this is only for holds related to failure to appears, there are other reasons that your client could have a hold, such as having too many points on their license, so they have a negligent operator suspension, or another common one that we see is can be for issues related to child support. So you do want to make sure that you know from the DMV what the basis of the hold is, but if you have that information, then and you know that's for failure to appear, this is sometimes a way to be able to address it. And then I do also want to talk about local programs because I think that that's an important thing to just be aware of. This varies quite a bit regionally, so but being aware of or on the lookout for whether there are any types of programs that your local court or a prosecutor's office may offer to address these types of tickets. So for instance, in LA City, well, LA, all of LA really, the city attorney has something called the HEART program. And this is a program where the city attorney will move to dismiss tickets for low income people. They have their own requirements as far as each of these programs. The programs are set up by by your local agencies. And so they're going to have their own rules as far as who qualifies for the program, whether there are any requirements as far as participation in services or community service or anything like that. So, some at various points have only been for people who are unhoused, is my understanding too. So those programs are going to vary quite a bit, but just being aware of them as potential options. I would say that I think it's always worth finding out what those programs are and really critically thinking about whether they are serving your client and your client community or not, depending on how onerous the requirements are, for instance, it may not really be a viable option for your client. Or, if people really, really don't want to interact with the city attorney's office, which is essentially, a prosecutorial office, then that may not be what's in the best interest for them. Other people really just want the tickets to go away, whatever that means or requires. And so these programs might be good for them. So I think we like to think about the programs really critically with our clients, think about the pros and the cons for them, but having an awareness of them, or also if you are in a county that doesn't have a program, but might benefit from one, thinking about what that might look like or what that partnership might be is something to just be thinking about critically with your own organizations and the organizers and communities that you all work with too. So that is that. I can move on to questions. I see that there's at least one here. I don't know if we'll have any more. So the question I see is, are there any important differences for how a case moves through court or options for resolving it if the infraction is based on a municipal code violation versus a traffic violation? I guess there are a couple. I'm actually going to end the slide. I'm going to stop sharing my screen so I'm a little bit more, so people can hopefully see me more. Yeah, so I think that the important things to know, generally the process for going through court will be the same. Where there may be some things more variables to think about are what are the possible consequences. So again, because traffic violations have things like the points, for example, you may need to think more about whether a conviction is going to carry different types of consequences that may be more problematic for some clients than others. But the actual process itself, as far as going through the court, will be essentially the same. Let's see. Next question. I recently had the DMV mandatory action refused to purge a failure to appear hold despite being more than 5 years old. The reasoning was that for offenses that carry a 2-point penalty, the penalty to purge is 7, not 5. I've never previously come across this situation. Have you ever heard of an FTA isn't eligible for purge after 5 years? Sorry, Justin. No, I also haven't heard. I haven't heard of that. And I guess if I were to come across that, I would be looking at the DMV's actual policy because my memory is I have actually looked up the policy before and they say 5 years. But no, that's something that I have not come across. All right, next question. How does your clinic receive clients? How do other lawyers find unhoused clients with these needs? Yeah, this is a great question. So, I think it varies quite a bit. I can tell you about a few different programs that I've worked in. So in my current program, we are located at the West LA VA, and here there are a lot of unhoused veterans who stay at the VA campus. So there's a few different things that we do as far as receiving our clients. We do a lot of outreach to the various programs with the VA here, so people know to refer their clients to us. We also, there is, for lack of a better term, like a tiny home village that is at the West LA VA. And so we do office hours there as well, make sure people know that we have our cases. So basically we're doing the outreach to try to find our clients that way. I've also worked at agencies where we received direct referrals from other organizations that work with unhoused people. And so we would provide services based on those direct referrals, or doing other types of like community drop-in clinics where they would come in just generally for legal assistance, and we would provide assistance there. So I think a lot of it, that we found as far as the success for the different programs is about being literally in the spaces where, our unhoused clients will be. So not necessarily always expecting them to be able to come up to our office or to be coming up to our office, but actually going to them and to their communities too. Um, could you talk a bit about options for appeal after traffic court decisions? I actually can't, because we have not had to appeal a traffic court decision. So I'm going to have to punt on that one. I'm sorry. I know that there is a process, but I haven't needed to do it. So I apologize for that. Have you ever used other tools in the penal code to fight back against infractions? I've used the mirrors for poorly written tickets, criminal discovery tools to sever sanctions, and motion to suppress evidence on occasion. Yeah, I mean, I think that's why I didn't want to get too much into the process. I think we think about it as litigating any other type of case. I'll be frank and honest. I think it depends quite a bit on what courthouse you're at, and how the decision makers kind of view these different cases. And so I'll also recognize that's going to vary, not just by the courthouse by courthouse, but also by judge by judge. And quite frankly, we've had a lot of success with requests for dismissals. And so that is how the vast majority of our cases are being addressed. And then thinking about the other components is on more of a case by case basis. But so I do think that's a really important point, though, which is that thinking about these cases like you would any other type of case, as far as needing to litigate them all the way through, is something that to keep in mind. But a lot of the value can come, quite frankly, in just even for our clients having an attorney who's able to kind of get through the process and kind of present their arguments to a judge, who the judges are often used to speaking directly to individual litigants as well. And so we know that, unfortunately, part of the truth is that often attorneys can be more successful in arguments that are the same arguments that unrepresented people are also presenting. See, do you ever see courts issuing bench warrants when a person doesn't appear on a ticket? And if so, how can a person clear the warrant? So I used to see bench warrants for tickets, for older tickets. I have not seen a bench warrant for a failure to appear for an infraction ticket in a few years. At this point, the way to address the bench warrant is like the same way as addressing any other bench warrant. So, normally we would contact the court where the bench warrant was issued, and just talk to them about exactly what that process looked like. Usually it was like a walk-in type of a process to at least clear the warrant, and then schedule the arraignment, if not clear the warrant and have the arraignment on the same day. But generally that is something that when we've seen that we would just contact the courthouse itself and ask them exactly what that process looked like. Usually it just required an appearance, and then they would clear the warrant at that point. Looking, are there any other questions? I see, sorry, one more in the chat. Do you have any literature or information regarding direct referrals to your services? So, I mean, our office we no longer require, my current office does not require direct referrals. So we do have the information for how people can get assistance by contacting our office. That's something that I can potentially provide to LAAC as well, but they basically just need to contact our office to receive services. We have a phone number for them. Okay. All right, I think that those are all the questions. I do want to give people like maybe one more minute, otherwise we are good to go. All right, thank you, everyone.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.